In the last video, we discussed two sets of potential objections to property systems. Number one, the possibility that there are situations in which we can achieve some of the purported benefits of property systems via other mechanisms. Number two, we may have objections external to concerns about building maximum wealth or maximizing aggregate utility that may make us, in certain situations, prefer not to have a property system. In this video, we're going to assume arguendo that we are trying to maximize aggregate social welfare and discuss potential costs of property systems that may get in the way of realizing that goal. And this set of objections, I think, is the most relevant for a student of property law in a first-year law course, because they provide an entry point for thinking about the consequences of particular property law doctrines and whether they promote or frustrate the ability of property law to achieve a goal of maximizing aggregate social welfare. And this in turn provides a basis for formulating arguments that may be persuasive to judges who share that premise. And there's a lot of ground to cover here, so we're going to break it up into two videos. This video will cover establishment costs, inefficient pricing, and transaction costs. And the next video will cover rent seeking and monopoly and the problem of externalities. So let's begin. So one set of property costs concern the establishment of a property system in the first place, and doing things to make sure it can run, things like establishing title records, things like figuring how one is to make their claim, choosing among claimants if we're talking about the initial establishment. There are costs to protection. One of the benefits of property rights is perhaps that the police and the courts will protect your interests, but of course the police and the courts are not free. Adjudicating disputes and maintaining the infrastructure necessary to do so is an ongoing cost of a property system that is part of the overall balance of costs and benefits. So one of the sought-after gains of a property system is the efficient use and, by extension, pricing of resources. But of course, it is possible for a property owner to price their resource in an inefficient manner, leading to an underutilization of the resource. So, for example, think about a parking lot in an area of town that gets some traffic, but does not get a lot of traffic, say, after hours. And maybe the parking lot owner decides to just lock up the lot, even though it would be costless to them to just open the gate and let people park there as they see fit. So the potential value of operating isn't enough to pay a parking attendant, but perhaps then that argues for opening up the gate and letting anyone park there rather than having the resource made off limits at that time of night. Now, I don't want to overstate this issue. The losses have to be balanced against similar misallocations or inefficiencies offered by a system of the commons or state ownership, but it is still a potential cost that would need to be considered as part of any holistic picture of the costs and benefits of a private property regime. In the earlier video about the potential benefits of property rights, I discussed transaction costs, the costs that are attendant on striking a deal that are independent of the actual values exchanged in the transaction. A property system may lower transaction costs by reducing the number of people who have to agree before a particular resource can be put to use. But it's important to keep in mind that transaction costs exist in a property system, and they may, in many cases, prevent the efficient use of a particular resource. Let's imagine our hypothetical pasture. Now it's owned by a farmer who is using it to farm, and there is an entrepreneur who is interested in building a hotel on the property. And let's imagine, hypothetically, that the land is worth $1 million to the farmer, and the land is worth $1.2 million to the entrepreneur. And those values reflect what each would be able to get out of the land. And so we can imagine that there is a hypothetical deal to be made. The entrepreneur is willing to pay up to $1.2 million. The current owner is willing to sell for $1 million, so somewhere between $1 and $1.2 million is the price that the parties ought to be able to reach. And since these values reflect what the two parties are able to get out of the land, a deal would result in the land being put to a more efficient use, producing more wealth for society at large. In other words, barring any kind of externalities, which we'll talk about in a minute, this is a transaction that we as a society should want to have happen under the utilitarian story of property. So, how can transaction costs get in the way? For one thing, there is the cost of bargaining. It takes time to negotiate a deal. That's time that could be put to an alternative purpose. But in other situations, we may have to hire people to negotiate on our behalf. So in our pasture hypothetical, suppose that it is a particularly complicated transaction, and both the farmer and the entrepreneur have to hire lawyers to negotiate on their behalf. And let's say, hypothetically, the cost of the lawyers are for each of them $150,000. That results in at least $300,000 in attorney's fees, in transaction costs that are not reflected by the value that either the farmer or the entrepreneur will realize from the transaction. This now makes the transaction impossible to accomplish. The farmer had been willing to take as little as $1 million, but if the transaction costs the farmer $150,000, the farmer will now need to have at least $1.15 million in order to sell the land. Likewise, the entrepreneur was willing to pay up to $1.2 million, but now the entrepreneur has to pay $150,000 in attorney's fees, and so that means the maximum value that the entrepreneur is willing to offer is $1,050,000, if I have my math correct. And that means that the transaction is now out of reach. There is no mutually beneficial deal because of the existence of the transaction cost. And there would have been a deal available if the transaction cost had not existed. In other words, the transaction costs of the deal result in a socially beneficial bargain not being struck. And lawyers aside, there's a wide range of things that may raise the price of bargaining for the parties. They may just find the activity of bargaining to be annoying. There may be animus between the two parties. Maybe the two parties don't speak the same language. In many cases, there are information costs to a transaction, trying to figure out exactly what it is you are bargaining over. There's a potential cost in figuring out exactly with whom you need to bargain. So in the pasture example, how does the entrepreneur figure out with whom they need to bargain for the land? And this is an area where property law actually does have mechanisms via title recording, which allows people to figure out with whom it is they need to bargain for a particular parcel of land. And this kind of gets us into the idea that you should be thinking about throughout a property course about not only is there an issue of transaction costs, but what can property law do to lower those costs so that socially beneficial transactions may occur? Another bargaining cost may arise among property owners who collectively may be buyers or sellers of property. Sometimes you may have a situation where multiple property owners are needed for a beneficial transaction to occur. So hypothetically, imagine you have a pasture land that has now been divided among, say 10 different ranchers. And a possibility arises of the land being used for a hotel. Tracking our earlier hypothetical, let's imagine that the entrepreneur is willing to pay up to $1.2 million for all 10 parcels of land. And let's imagine that each of the individual parcel owners would make a profit and would be willing to part with their parcel for $100,000. And let's imagine that the entrepreneur and one of the group's representatives get together and they agree on a price of $1.1 million for all 10 parcels. This should be a profitable situation. The entrepreneur gets the parcels for $100,000 less than he would have been willing to pay. each individual parcel owner gets $10,000 more than they would have been willing to take. But we have the possibility now, the hypothetical, that one of the individual parcel owners might try to hold out, might try to say, hey, I insist that I get to have, say, $130,000. And the problem is that if everyone makes the same kind of demand, the deal is off, because now it would cost the entrepreneur $1.3 million. But every individual parcel owner doesn't want to be taken advantage of, and so no one is going to say, yeah, you get to have $130,000, but we are all going to be content with less. We have a coordination problem that needs to be resolved. And this is a cost. The potential problem of the holdout is one of the things that needs to be worked through in this kind of setting. And there's an analogous problem that has been referred to as the tragedy of the Anticommons, referring to situations in which a resource may be underutilized because many different owners or many different parties have the ability to exclude others from engaging in a utilization. There's also transaction costs sometimes of delineating what the precise boundaries of a property right are. And so that's maybe not such a terrible problem when we're dealing with land, which may be subject to meets and bounds deeds, where you can hire a surveyor and figure out exactly what the border of somebody's property actually is. But sometimes boundaries can be a good deal more vague. And in an earlier video, I talked about the hypothetical problem of two neighbors who have incompatible desires for their uses of land. One neighbor wants to start a coffee shop, the other neighbor wants everything to remain residential. And depending on the circumstances, the neighbor who wants to keep things residential may have the ability to bring a nuisance claim against the would-be entrepreneur. But the question of whether a court would find that the entrepreneur's desired use of the land is unreasonable may be hard to ascertain ex ante. And the fact that the result of a nuisance suit between the two neighbors may be indeterminate will frustrate the ability for them to negotiate with each other. And again, the idea of reducing transaction costs is often used as a justification for why certain resources should be governed under a property regime, but sometimes the commons may be more efficient. So we'll leave it there for now. The next video will discuss the problems of rent seeking and externality.